May be seated. Board is back in session. Our second case today is 24-15-12 Osceola County versus Orange County et al. And if I could please have counsel at the tables identify themselves.
Yes, Robin. Lee Barbaugh here for the appellate, English County, Florida.
Kimberly Cole for Osceola County.
Shane Stoffa.
Okay. All right, and how much time would you like to reserve for rebuttal? Okay. Just remind everybody, please turn your phones back off if you turn them on during the break. And Ms. Foley, you're recognized.
May it please the court, Beverly Pohl from Nelson Mullins for Osceola County. Somewhat ironically, this is a case that's a dispute between two Florida counties that have worked cooperatively for 30 years on the subject of the Split Oak Forest Mitigation Park. They've entered into several agreements between themselves and including agencies of the state of Florida, and they both own part of the Split Oak Forest and they manage it along with the state. In 2019, I believe it was, both counties issued resolutions saying that they were in favor of a location in the very southernmost part of Osceola County that would have allowed for a highway extension, a toll road extension to cut across the bottom of Split Oak. And as part of that agreement, there were going to be 1,550 acres added to Split Oak to kind of more than compensate for the 60 acres that would be impacted by the road. And that troubled some people who didn't want any development at all. And a charter revision committee was formed to consider a revision to the Orange County Charter. And they came up with something that is rather striking in its language. And if I were to try to propose an unconstitutional or invalid charter provision, I think I might start it this way. Notwithstanding any general or special law of the state of Florida and its agencies to the contrary, then it goes on to say what's going to happen. And it's really unthinkable that a county law would purport to act notwithstanding state law. That's just not the way it works in the hierarchy.
Counsel, do we have, in order for Osceola County to prevail on appeal, do we have to make some finding that Article 10 of the charter is unconstitutional? Or is there a way for you to win without it being unconstitutional?
I've thought about that question, and certainly there was no constitutional claim in the second amended complaint, but there was a claim that it was invalid because it conflicted with state law. And I don't know if that's cutting it too close, because it's the same argument, really. The Constitution says state law prevails in the event of a conflict. And we showed that the charter or the amendment, which is Article 10, conflicts with section 704.0611. That statute says that no law shall be construed to prohibit owners of a conservation easement from considering the development of certain types of things, one of which includes a roadway.
Counsel, I share Judge Brownlee's question. If we grant you the argument that there is a conflict, and understanding that you grounded your argument in the Constitution that there can be no conflict, that the charter can never trump a statute always trumps the charter. But if we find against you on waiver, right? And the only argument you made is grounded in the Constitution, I come back to Judge Brownlee's question, which is that prohibition anywhere else in the law other than the Constitution? Is that come with us to common law? Can you root that in anything other than a prohibition in the Florida Constitution?
Well, I think if you read the language of section 704.06, it says no law shall be construed to allow this to happen. And in fact, this county law says on it, you don't have to construe it. It
But isn't
says-
that the problem? If we don't, excuse me, if we don't have to construe Article 10, then doesn't that cut against your argument, excuse me, about 704.06? Because it says construe. So, and I take it like, I get the idea that these two things can rub up against each other, right? They look at surface level like they're inconsistent, but it's what you just said. We're not construing the charter, the Article 10 of the charter, right?
You only have to construe something if it's somewhat unclear. In this case, it's on its face. On its face, it conflicts with state statute. So I think that
But the state statute would be 704,
that's,
right?
that's correct.
704.06 sub 11.
Yes.
So if that is talking about when we construe laws or language, and we're not having to do that here, how is it inconsistent? I mean, wouldn't we have to read the word construe out of that statute? That's what I'm concerned about this argument. Setting aside the
I
constitutional
don't
problem.
think so. I think that's reading more into the word construe or maybe reading less into it, because you don't have to figure out what Article 10 means. It tells you what it means. It says the Orange County Board may not ever permit removing restrictions on the use of the land in Split Oak. And the statute says that the owner of a conservation easement must always be allowed to negotiate for these types of changes, including
Council, what'd you say?
erosion.
It actually doesn't say that. It could say that. It could say may not prohibit or limit. But it says may not be construed, which I think it's Judge Brownlee's point. Is this not a statute on that basically provides a rule of construction for how we should read?
I just don't think it makes sense to say that a facially violative provision can survive where a less clear provision that might need construction would be stricken. That makes no logical sense in terms of how to view these two laws in.
What do you think the word construe is doing in the statute? What work is it doing?
It's trying to make sure that nobody reads another law in a manner that gets around 704.0611.
So if we accept your argument as true, and we think that that is right, we still have the idea that those two things can only, the problem with them being inconsistent, assuming they are arguendo inconsistent, the problem with that is that it would violate the Constitution, right? So then we get back to this waiver problem that I think might be the elephant in the room. So how do we get around? Is there some way to get around Lee Memorial and the express language of the rule?
I think that Lee Memorial, believe me, I realize Lee Memorial is a hurdle I have to get over.
Yeah.
But there are a number of ways that I can distinguish that case. First of all, the statute that was at issue in that case that was being challenged was in fact, it was a state statute. They weren't construing a county charter amendment. So that is a little different. And as you know, courts, and especially the Supreme Court, they decide the case that's before them. So really, they haven't yet decided what the preservation requirement is with regard to a charter amendment. But assuming that it does apply here, the statute at issue in Lee Memorial was declared unconstitutional for a second reason. So the fact that they never got to Article 1, Section 10 in that case was almost irrelevant, because the statute at the end of the day was unconstitutional and unenforceable. And if we don't, in this case, find Article 10 to be invalid, as we argue you should, then you have the one and only, I guarantee you, the one and only county law that purports to operate notwithstanding contrary state law. And that just goes too far in announcing what the scope of the county law is. And so I think, with regard to Lee Memorial, there's nothing in there that suggests that there was a waiver there. it doesn't really say this, but one must assume that there was an objection to the fact that there was no notice given to the Attorney General. And here, Orange County was completely silent during the entire litigation in the trial court about the fact that the Attorney General wasn't given any notice. And I believe that was a waiver. There are many
But is that
cases-
theirs to waive? This is my concern is there some case where one party could waive that on behalf of a non-party? Like, it seems like it's not theirs to waive. And all of the cases that were cited in the briefing and the initial and the reply brief deal with a situation where the party would be waiving its own right. And here it seems Orange County would somehow be waiving that on behalf of both the Attorney General or the state attorney assigned to that jurisdiction.
Well, they're the litigant, they're the party in the case, and that would be a defense that that party could raise. And if it's a defense that they could raise and perhaps should have raised, they didn't raise it. And that, I think, constitutes a waiver. And to the
Is it a
extent,
defense, counsel?
pardon me,
Is it a defense?
I think it would be a defense.
It's not part of your cause of action when you ask for a declaration that something's unconstitutional. that
Well,
you
this
have
is,
to-
this is where we get into the tension between one party's obligation to do something, any kind of notice requirement, any kind of condition precedent, and the other party's obligation to object. And this happens all the time. One party doesn't do something that they're supposed to do, and if there's no objection, they get to do it.
But
But that goes back to Judge Brownlee's original question. Do you have any cases where it's a non-party?
No, I don't have any cases where it's a non-party, but
Wouldn't that be kind of a bizarre, like, I'm trying to think, if we wrote this the way Osceola County would have us write it, where it was a reversal, and we attack this issue that's fairly raised by the parties at this stage, then wouldn't our reversal, I struggle, so it would say, we find this unconstitutional because 704 conflicts with Article 10, and that sort of thing is prohibited by the Constitution. And it doesn't, the Attorney General and the state attorney have not had, certainly not a prompt notice of that. So they had no opportunity to be heard. But notwithstanding that, we think that Orange County could waive that rule of procedure and that entitlement to be heard on behalf of the AG's office. That would be, I don't know, that's hard, that's a hard right.
then I think you could analyze the case slightly differently. One is that it would be fundamental error to allow a county provision to stay on the books when it says that it operates notwithstanding contrary state law. That is the fundamental nature of the structure of our government. State law predominates.
But
is
in that state-
constitutional?
Pardon me?
Sorry.
Go ahead, Judge Nardella.
I mean, the structure of our government, it violates the structure of our government. That's also a constitutional problem. It may not be a specific, I mean, it's the division of powers.
Right, but I just don't think it makes any sense to allow that kind of language to stay on the books. Let's turn to the breach of contract, because that's another ground. And maybe you can just look at the contracts rather than the contract clause to show that the contracts allow the parties, and when I say contracts, I mean the interagency agreement and the grant award agreement that both counties were parties to, as was the state of Florida. And both of those documents have provisions that allow the parties to amend its provisions when the circumstances require. And I'm just going to refer the court to the record pages. 998, section paragraph 6 refers to modification of the interagency agreement. And at page 1004 in the grant award agreement, paragraph 3, it says this agreement may be amended at any time, and it has to be agreed to by both counties and FCT, Florida Communities Trust. And so what Article 10 has done is hamstrung Orange County's Board of County Commissioners, which had been completely in favor of the Osceola Parkway extension. And it's said that the Orange County Board of County Commissioners may not approve that. And that certainly changes the nature of the contractual agreement here. And I think this court could find that that is a breach of contract and that Article 10 is invalid for that reason.
What provision would it breach?
The ones that I just,
Well, let me ask this. Maybe that was a poor question. The governing documents, the interagency agreement, the grant award agreement, the deed of conservation easement, do they dedicate any provision to saying the mechanism for which assent should be given or agreement should be given by one party?
no, but I think it has to be in writing. It does say that.
But how they internally, and I think this goes back to Orange County's argument, how they internally make that decision. So it's a practice that was incorporated into these agreements. Is that the argument? The practice was that the Board of County Commissioners would always make the final decision. And that practice is no longer in play.
But it's fair to say that Osceola County and the state of Florida would not have entered into an agreement with Orange County in which Orange County was forbidden from ever making any amendments or modifications, because they recognized that amendments or modifications might be a good idea in the future. Now, they still have to be approved by everyone. And it is true that Orange County says they always retained the right to not approve it, but they also retained the right to approve it. And that right has been taken away. That's a contractual expectation. And that breach of contract is clear, even without talking about the Florida Constitution. I know I'm getting into my rebuttal time. I just want to say one thing about the ballot provision and the summary, because I think that that's an argument that should not be overlooked. We all know what the standards are. The ballot title and summary have to be fair. They have to inform the voters. And there is nothing in either the title or the summary that fairly informs the voters that this pertains to the Osceola. This was motivated by and really is directed at the Osceola Parkway extension. Nor does it tell them that if that extension goes through, that 1,550 acres would be added to Split Oak. So it's worded in such a way that the provision is solely to protect Split Oak, but in a way, it precludes Split Oak from getting the benefits that had already been proposed and at least provisionally agreed upon by the parties. So under Askew versus Firestone and all of the requirements that fair notice has to be given to a voter so that they can intelligently place their vote, I think it really should be stricken from the Orange County Charter.
As a neighboring county, you feel you have standing to raise that?
We absolutely have standing under the declaratory judgment action because we have an interest that is affected by this. I mean, in fact, it's very unusual, but the charter provision lists portions of Split Oak that are located in Osceola County. So it's very clear that they're regulating land that is located in Osceola County.
But you have an interest insofar as they're regulating that land located in Osceola County. I grant you that. But do you have an interest insofar as Osceola County would need to be informed on how to vote on a ballot? Wouldn't those be two different things? So the right to be informed about something and to not have the ballot summary, be vague or ambiguous, or as you're stating, they're not being fully transparent with all the benefits that could flow from this. But that ballot summary to inform voters, isn't that distinct from your interest or Osceola County's interest in just how this is going to affect this agreement and this land?
No, I don't think it's separate because of the 30-year history that the two counties have and the contractual agreements that they've had and all of the efforts that have gone into the whole Split Oak Forest mitigation park. And the fact that Orange County listed our land in their charter provision tells you that it does affect us. And so I think that the standing requirement is not so rigid in a declaratory judgment action that it would exclude us from making the arguments that we're making here today. I'm going to reserve my 1 minute for rebuttal. Thank you.
Mr. Burbine, you're recognized. Oops.
May it please the court. My name is Lee Birnbaum. I represent the appellee of Orange County, Florida. The final judgment entered by the trial judge in favor of Orange County was properly entered, and it should be affirmed by this court. As your honors are now well aware from reading the briefs, appellant's arguments essentially are threefold. One, they say the charter provision is inconsistent with state law. A lot of that is citing to 740.0611, which I'll address. They secondly argue it breaches the governing documents. And third, that the ballot title and summary were misleading.
Can I ask you to go right to number 2 and address her argument about the breach of contract claim and whether Article 10 violates these agreements, the interagency agreement, grant award, deed of conservation?
Yeah, yes, Judge Brownlee, of course. It's our contention. We think that it absolutely does not violate them. Their whole argument about arguing it's a breach of contract is these amendment by mutual agreement clauses. And what they say in each case, and in each case, I mean the interagency agreement, the grant award agreement, and the conservation agreement, all say specifically that the amendment may happen in the future. The interagency agreement, this agreement may be modified, requires approval of all parties. Grant award agreement, the agreement may be amended. The conservation as may be amended by mutual
But we
agreement.
aren't taking away the word may, right?
Well-
Or are we?
Well, I don't think so, because I think what Osceola is arguing, in my opinion, incorrectly, Judge Brownlee, is that somehow the charter provision and Orange County are separate. Orange County is governed by its charter and its code. Orange County has the right to regulate through laws, in this case, a new law, what it decides to do in the future. It's not like the charter independently prohibits the Board of County Commissioners and what they can do. The charter is an entire governing document in all cases, whether it's zoning or planning issues or how they vote or what public notice. The Board of County Commissioners is governed by the charter. So Orange County has a right through a charter amendment to say we are not, despite that there were agreements that say these may be amended, we are not going to amend these agreements in the future if such amendment or other agreements have the effect of limiting or restricting the conservation and environmental protections in place. And they have the right to do that. If you have a right, I'm sorry, Judge.
Do you see a distinction between a wholesale prohibition and then a direct vote by the voters on an individual modification? Do you see what I'm saying? I understand your argument, but the fact that they've prohibited, what they've taken off the table is consideration.
Well-
Does it belie these governing documents that there will be consideration given to individual requests for amendments, and that consideration is now being, and I don't use that in the contractual term, that's probably a poor.
I understand. Respectfully, I would say no, because there's nothing in the governing documents or the amendment by mutual agreement provisions I just cited to that say what the process to amend is.
Correct.
They simply say that it may be amended and all parties have to agree, and it has to be in writing. There's nothing that talks in any of the contracts about what the process or the consideration or the interpretation about whether to amend is or is not.
We understand that.
And I'm just trying to answer the question. And part of the other answer, I think, as I cited to in my brief, is if there was no charter provision at all, Orange County would have the absolute right to refuse to amend any of these agreements, whether it related to the Osceola Parkway extension or otherwise. So to have something that codifies how they're restricted is not a violation or breach of those agreements. It
When it-
doesn't change. I'm
I-
sorry, Judge.
When it comes to the breach of contract argument and not to the 70406 argument, taking those separately, but when it comes to the breach of contract argument, would the answer be any different if every single county commissioner ran on a promise that they would never amend?
And when you say would the answer would be different, can I make sure I understand your question?
Sure, and maybe this is a better question for opposing counsel, but if every single county commissioner ran on the fact that I promise my constituents, I will never amend Charter Oaks,
Mhm.
I'm sorry, would
Split up.
would
Yes,
never
ma'am.
amend Split Oaks. Would that be a violation
No.
Would that be a breach of contract?
I'm sorry, I didn't mean to interrupt. No, I don't think at all. I think any commissioner, whether it's a sitting commissioner or challenge, could run. That can be part of it. Often they do run on issues regarding the environment and development or not development and where it will be. No, I think they have the absolute right to do that.
So
I
and
guess there could
voters
be
weigh in
a,
in two different ways. Does it matter? Voters weigh in through electing a county commissioner who says, I promise to never, ever, and voters weighing in through a ballot initiative.
no, I don't think it does matter. And in this case, 86.4% of the voters decided to approve this charter amendment. And by doing it, they're saying, we want this protection in there. We want this restriction on what the county commission can or cannot do as it relates to Split Oak, whether amending existing agreements or future agreements. And I think there's a right to do that. I don't think there's a distinction, to answer your question. And
Do
I
you
think,
think that that breach of contract claim is dependent on a constitutional argument? Or do you think it stands alone from that? I mean, I know that it was, I think, my recollection at least is that in the briefing, it was in the context of, not impairing the contractual rights. Bless you, Judge Stargell.
yeah, candidly, Judge, no, I think they can make those independently. As you know, and as your honors asked opposing counsel, I think their claim that the contract is a violation of the Article 1, Section 10 impairment of contract clause, I think they've clearly waived that. They didn't file a notice under 1.071. And one thing I want to correct about that before I go back and address the rest of your question, Judge Brownlee, is appellant's counsel said that Orange County never raised that in the litigation. Well, they never raised the constitutional argument. The second amended complaint, the operative complaint, made no claims, whether because of Article 1, Section 10 or Article 8, Section 1G, that any part of the charter provision was unconstitutional. Their prior iterations never raised it. In 3.5 years up to the summary judgment motion, they never raised it. They raised it for the first time in their response in opposition to the summary judgment. And even then, they never filed a notice of constitutional challenge. They never put State Attorney General on notice. The first time they did that was in the appeal. And a month later, I objected to it, said, in all the cases, Lee Memorial Health System, because it's Florida Supreme Court case, is probably the most relevant, but every DCA has said courts are prohibited from addressing that issue when they don't do it.
Do
But
they-
I agree that,
Do those cases, counsel, with regard to this notice provision, the purpose of my question is to discern whether it matters that the trial court found it was constitutional as opposed to unconstitutional. Do any of the cases relied upon by Orange County involve a situation where there was a notice problem, but there was a finding of the trial court that it was constitutional?
not that I'm aware of, but this is a little bit different because, in my opinion, Judge, because they challenged the charter provision saying it's invalid. And so, yes, part of our argument was, hey, a charter provision is valid as long as it is not inconsistent with Florida Constitution, general law, or special law. So we made that affirmative statement as part of our defense and as part of our summary judgment motion, because that's part of the standard. The case law goes on to say where there is no direct conflict, appellate court should indulge every reasonable presumption in favor of the validity or constitutionally of the presumption. So to answer your question, no, I'm not aware of the Lee Memorial case or another one where the trial court said it's constitutional, but I think because of what they challenged and what the standard is, that's why it came up here. But there is, I would also point out, there's no difference or distinction between the Lee Memorial cases or this case. I think any attempt to do so is really kind of twisting yourself in a pretzel. There was no fundamental error alleged in any of those cases. It was the exact same situation in Lee Memorial as here, and that is they tried to raise a constitutional challenge way too late in the game. They tried to file a notice of challenge, a notice to Attorney General way after they were supposed to, and in non-compliance with a rule that said it has to be prompt. And the court said, you cannot do that. We cannot consider it. To answer your question, though, I want to make sure I did answer it. I do believe that appellant can make the argument that the provision is a breach of contract without having to just say it's an impairment of the contract. And so we address that. And my counter really is there is no breach for the reasons I've said before. And that is, if we have a right to not amend in the future, regardless of the charter provision, and all the charter provision does a governing document of Orange County is say, Orange County is not going to amend, not going to exercise its right to amend in the future under certain circumstances, it's perfectly valid to do so.
Is it almost like an impossibility argument? I mean, sort of what good is the contract at this point until the voters speak again?
Well, I don't know that I would argue that. I mean, the contract has a lot of provisions. The interagency agreement and the interagency agreement governs between Osceola, Orange, and FWC and governs the management of that land and the setup. It's still in place and it still goes. The grant award agreement, which had to do with state through FCT funding to the recipients, Osceola and Orange County, is still in place. No amendment has even come before. There's nothing in the record to show any amendment has come before the Orange County Board that has been rejected. And again, there is an exception where Orange County, in the charter provision, where Orange County's Board of Commissioners do have the right to approve an amendment or a new agreement related to Split Oak if it provides greater additional or more stringent protection. So no, I don't think it's an impossibility. They've just set very strict standards under which they will or will not be permitted to do so. I want to address 740.0611, if I may, as well, which is, I think, the main argument, and I don't want to speak for appellant, but the main argument where they argue it's inconsistent with state law. And it simply is not. You have to look at 704 respectfully. I would ask the courts to look at 704.0611 in the context of the entirety of 704.06. And that's what all rules of statutory construction say, is look at the clear, plain language of the statute, look at it in the context. So 704.06 talks about conservation easements and the protections under which they serve. 704.06(1) and 2 express that conservation easements are perpetual and run with the land and are binding on subsequent owners. It talks about how there can be a prohibition on conservation easements for the construction of roads and other activities inconsistent with wildlife, water, vegetation. And subsection 4 also talks about how they run with the land. Now, all 704.0611 then comes in and says this section, nor other law. So despite all the protections that you have for conservation easements, and despite that they're perpetual, is don't interpret that to mean that the owner of a land or owner of a conservation easement over land cannot voluntarily negotiate. It says, you know, a law may not be construed to do that. Our charter provision, first of all, doesn't construe 704.06 at all. It doesn't say that we are putting in this prohibition because 704.06 or any other law requires conservation easements to never have roads. It was a separate document. It doesn't indicate how Osceola County has to construe it. So the word construe is critical. Contrary to what I think appellant has argued, at least in their brief, 740.0611 doesn't say no law can limit voluntary negotiation. It says this section or other law may not be construed to prohibit it. So this provision, especially when read in the entirety of 704.06, first of all, is entirely consistent with our charter provision. It doesn't require roads to be put on conservation easement. And again, Orange County can decide whether or not to voluntarily negotiate, hence the word voluntary. And this is, again, where I think Osceola County is trying to make a distinction between the charter and Orange County. It's the same thing. This is a mechanism, the charter provision by which Orange County said, we are not going to voluntarily negotiate. And so there's nothing at all inconsistent with 704.0611 and with the charter provision. And that, I think that's true just on the face of the statute, but I would also, and I think I cited to it before, the city of Kissimmee versus Florida Retail Federation Incorporated Fifth DCA case, which says where there is no direct conflict, appellate court should indulge every reasonable presumption in favor of the constitutionality of the provision. Now, I want to talk, and I'll circle back if I have time, of course, answer any questions, but as to the ballot language, we don't believe Osceola County has standing. And to be clear, our argument about their lack of standing to challenge the ballot summary is different. We're not making an argument that they do not have standing to challenge the charter provision through a declaratory judgment or otherwise. So I think Osceola is kind of conflating two different standards. Do they have standard under Chapter 86? Do they have standard to challenge a ballot language? And the city of Hialeah versus Delgado case, which we cited to, makes clear that it is a voter or a citizen of the county that has standing, period. And in fact, the city in that case even tried to make an argument that the person challenging the city ordinance didn't have standing because they were making the city mixed up standing to challenge an election and a taxpayer standing to challenge how a state uses certain revenue and whether they're directly impacted. And in that case, the third DCA directly said, no, Delgado has standing to challenge, make a 101.161 challenge because he is a voter and a citizen. Osceola is neither. It has no standing to challenge the ballot summary. That being said, based on the clear case law, and the trial court correctly found, the ballot summary meets all the requirements. It states the primary purpose of the charter provision, and it is not affirmatively misleading. As this court knows, most of these go before the Florida Supreme Court, who often issues advisory opinions, and the standards are really clear. And what the courts have consistently said in the Florida Supreme Court is that a proposed amendment, and this is true whether it's a constitutional amendment or a charter amendment, should only be found invalid only if the record shows it is clearly and conclusively defective, meaning it's clearly and conclusively misleading or fails to state its chief purpose. That is absolutely not the case here. And I think one of the most important cases is the most recent one I cited to from the Florida Supreme Court on election challenges. It's the advisory opinion to the Attorney General regarding limiting government interference with abortion. And in that case, the Florida Supreme Court talked about what the key question is, and what the key question is not. And it says, while it may be true the proposed amendment could have broad effects that are not fully explained in the ballot summary, a ballot summary does not have to explain every detail. It doesn't need to provide an exhaustive explanation. It's looked at as if the voter would educate herself or himself on the possible effects. The Florida Supreme Court in that case also went on to say, the question is not whether the proposed ballot language is free of ambiguity or whether there are uncertainties on the legal effect. They also said this court doesn't have the authority to rule on the merits or wisdom of it. What the court is simply doing is looking at the ballot language and the title and summary and comparing it to the text of the charter provision itself. And the trial court did it in this case. This court can do it, and they are entirely consistent with each other. The argument made by Osceola County that somehow the ballot summary in 75 words or less had to include talk that this was motivated by the Osceola Parkway Exchange and there could be more acres coming to Split Oak is just simply not required by any reading of any Florida Supreme Court case. Additionally, while clearly the Osceola Parkway Exchange was the impetus for the charter provision at issue, the charter provision isn't limited to the Osceola Parkway Extension issue or contracts related to that. Instead, it's related to Split Oak forest as a whole and any amendments to the existing governing documents and any new agreements that would restrict it.
Should we
So-
be troubled by the language in the beginning of Article 10, notwithstanding any general or special law of the state of Florida?
Thank
What
you.
about preemption?
Yeah, thank you for bringing that up, Judge, and I meant to address that to talk about it. It's inartfully worded. However, when you look at the charter provision as a whole, there is nothing in it that indicates Orange County believes, contrary to all the law, which we know, that the charter is contrary to state law. In fact, the rest of the charter provision, you see provisions where we expressly recognize the superiority of state law. In fact, it says in the severability clause that this provision should be interpreted consistent with superior state law and superior federal law. We know that state law is superior, and there's nothing in this, when you read the provision as a whole, that is intended to supersede that well-known effect. For all those reasons, I'd ask that this order be affirmed. Thank you. Sorry to go over, Judge.
In my 1 minute, I would just like to point out that they knew when they gave this to the voters that it was a problem. If you read Exhibit I to the motion to the second amended complaint at page 1040 of the record, the Split Oak Forest Committee recommendation acknowledges in the section called Arguments Against Recommendation that Florida law permits transportation corridors and linear facilities, which are roadways, through conservation easements. And they go on and they talk about section 704-0611. They knew this was a problem. And nevertheless, they submitted it to the voters, knowing that it was a problem. And now that problem is before this court. He talked about, Counsel for Orange County talked about the language in the agreements that says that they may be amended. And now what we've got through Article 10 is that Orange County may not amend them. And yes, it always had the power to say, we don't want to at this time, but now they don't have the power to say, we agree. And that's the problem here. This court should reverse the summary judgment.
Thank you, Counsel. All right, thank you for the informative arguments, and with that, court is adjourned.
Thank you.